Jacob Zuma and the Umkhonto weSizwe party have called for 6 constitutional court justices to recuse themselves from hearing the IEC's matter involving the former president. The court is expected to hear the Electoral Commission's application on Friday. The IEC is seeking clarity from the court on its implementation of Section 47 of the Constitution. This is the same law that the IEC used last year to disqualify Zuma from the 29 May ballot. But that decision was overturned by the Electoral Court, prompting the Commission's appeal to the Apex Court. According to Zuma, Chief Justice Raymond Zondo, alongside judges Madlanga, Majiedt, Mhlantla, Theron and Tshiqi, are all tainted by bias and are therefore not fit to hear the matter involving him and his new party, MK. And joining me now to help us make sense of all of this is legal analyst and head of legal at the Institute of Elections Management Services in Africa, Nkululeko Tselane. Good morning and thank you so much for joining us. Does Jacob Zuma have legal ground?
Good morning, challenge to your viewers. So what we have to remember is that the test for recusal of a judge is of bias by a reasonable third party who is well informed. So looking at the test, the MK party and the former president set out that because the 6 justices sat on the matter which convicted him to 15 months in prison, they're somehow biased. However, I do not believe that has any legal basis, because there is nothing that precludes a judge from presiding over a litigant that has been in front of them before.
All right. So in other words, you're saying that former President Jacob Zuma doesn't have a strong case?
No, he doesn't. So it's not unusual for judges to sit before matters that they've previously decided on. So as we know, if you want to appeal a matter, you have to do an application for leave to appeal in front of the same judge that potentially ruled against you. And also, when you're dealing with the recusal application, you also have to be dealt with by the same judges. So there is no strong legal basis, and a judge must hear a case unless the test for bias, or at least the appearance of bias, is properly met.
All right. And surely the former president, Jacob Zuma, would have consulted broadly legally with his team, and they would have advised him as such. What do you think is the reason that he has appealed for the 6 judges to recuse himself?
So what you have to remember is that in litigation, there's always a strategy towards how this is approached. It's not the first time that the former president has brought a recusal application. As you'll remember, during the Commission of Inquiry, he brought a recusal application against Chief Justice Zondo, which Chief Justice Zondo presided on and then ruled against. So the strategy is really what they would be thinking. If 6 constitutional court justices have to recuse themselves, then the constitutional court would not reach quorum. So there are 11 judges, and at all times there have to be at least 8 judges for there to be a quorum on a matter. So there wouldn't be quorum there. That would have to be brought into the matter in order to make sure that the constitutional court has judges available. Really, this litigation strategy we viewed in court. However, I do believe that as the any apprehension or for there to be any recusal of those justices.